Joining us on this important discussion today. Before we get started, some quick housekeeping notes. If you have sound issues on Eventbrite, please go to the Zoom logo to watch directly via Zoom. We are also live streaming the discussion on our YouTube and Facebook pages. You can grab those links in the chat. We have closed captioning available for viewers on Zoom. You can turn on the captions by clicking on Show Subtitle under More options under your screen. If you have questions for the speakers, please put them in the Q&A panel. We'll save some time at the end for those questions at the end of the discussion today. And right now, I'd like to kick off our conversation today on the basics of the Equal Rights Amendment. We're calling ERA 101 by acknowledging that 80% of the people in this country think that we already have an Equal Rights Amendment. So for those of you on the call who know we don't yet have constitutional equality, you can see the uphill battle we have before us in educating the American public on the need for the ERA and how we can get across the finish line. That's where all of you come in. After this town hall, make sure you talk about the ERA with your friends and networks and how important it is that we get sex equality into the Constitution, and take your values to the polling place with you on election day. Now, I'd like to turn over the discussion to our DC Director and Director of Outreach and Partnerships, Bettina Hager. Bettina?
Thank you so much, Zakia, and thank you to our speakers and everyone on Zoom or streaming for joining us for this important discussion and background on ERA 101. I'd like to start our conversation off with just one of the most concrete and heartbreaking examples of why we need the Equal Rights Amendment. Jessica Lanahan is a courageous advocate for justice, an example of the tragic injustice that happens in the absence of constitutional equality. Jessica was denied justice when the town of Castle Rock, Colorado's police department refused to enforce a restraining order against her estranged husband. Despite calling the police department 7 times and going to the station twice, no action was taken to return her daughters to safety. As a result, Rebecca, Catherine, and Leslie's lives were needlessly cut short that night. Jessica took her case against the town of Castle Rock's police department all the way to the Supreme Court, which ruled that Jessica had no constitutional right to enforcement of the restraining order. She continued to pursue justice and won her case before the Inter-American Commission on Human Rights based on international standards with ERA language that is not yet in our own Constitution. She is now working to advocate for the passage of the ratification and recognition of an Equal Rights Amendment so that all women and girls are afforded constitutional rights to protect them against discrimination and violence. And now we'll hear some recorded remarks from Jessica herself about the importance of the ERA when voting. A key takeaway from her tragic story is to keep equality in mind when you go to the polls each and every year.
My name is Jessica Lanahan. I am a human rights advocate on women and children. I reside in Colorado and have been part of the ERA for many years. Equality means to me that had the female gender been recognized as important in 1999 at the time of my children's murders, there may have been a different outcome. And I do believe that Lanahan versus USA was able to provide some protections in giving the ERA credence to be able to write the law that we so desperately need for equality. I believe that Indigenous rights on women is a very important topic. Native American women are undocumented, and we are not protected in any faction. We are a forgotten people. And I believe that our government must do better in providing those basic needs that are so lacking in their environment, in their residential areas, in their homes, in their lives. And it's a big cry and shout out to those that can make the difference and moving past the November vote to continue seeking those remedies for all women. Thank you.
Thank you so much. And it's always so moving to hear from Jessica and her story. And I think just the motivation that I get every time I speak with her on moving this movement forward, as well as we talked about earlier, making sure that we go to the polls to insist that our leaders take our rights seriously. And now I'd like to introduce our esteemed speakers. First, I will introduce Dr. Michelle Bratcher Goodwin, who is a Chancellor's Professor at the University of California, Irvine, and founding director of the Center for Biotechnology and Global Health Policy. She is also a global thought leader and advisor and the host of the popular podcast On the Issues with Michelle Goodwin at Ms. Magazine. Her writings address pressing matters of law, society, and global health. An award-winning author, her publications appear across 5 books and more than 100 law review articles, book chapters, and commentaries. Her opinion editorials and commentaries can be found in the New York Times, LA Times, Salon.com, Politico, Forbes, the Christian Science Monitor, and other platforms. Her latest book is Policing the Womb, Invisible Women and the Criminalization of Motherhood. Thank you so much for being with us, Michelle. I'd also like to introduce Dr. Julie Suk, who is a professor at Fordham University School of Law and an interdisciplinary legal scholar focusing on women as constitution makers at the intersection of law, history, sociology, and politics. Her broader research interests include constitutional and social change, anti-discrimination law and its effects on social inequality, women, work, and family, civil litigation as an enforcement mechanism for public law, access to justice, including the past and future role of non-lawyers in solving the civil justice problems of poor and middle-income people, social, political, and legal theory, and law and literature. Her book, We the Women, The Unstoppable Mothers of the Equal Rights Movement, was published in 2020. Thank you, Julie. And last but certainly not least, we have Jennifer Carroll Foy, who ran and won her race for the House of Delegates while pregnant with twins in 2017. She proudly served as the representative for the 2nd District, where she carried and passed bills to end pregnancy discrimination, reduce the Black maternal mortality rate, and it was her Equal Rights Amendment resolution that passed, making Virginia the 38th and final state needed for ratification. As a former foster parent, public defender, gubernatorial candidate, and one of the first women to ever graduate from Virginia Military Institute, a historically all-male college, Jennifer has dedicated her life to public service. She is currently running for state senate for the 33rd District in Fairfax and Prince William counties. So I just wanted to take a moment and thank you all for being with us. I think someone said earlier, this is a powerhouse panel, and it truly is. And we cannot wait to begin this discussion and go on to ERA 101. So as this is ERA 101, I want to provide just a short synopsis, which our legal scholars can expand upon, on how you ratify an amendment. So according to Article 5, the amendment must pass with 2/3 support from Congress and be ratified by 3/4 or 38 states. That's it, right? Okay, yes.
Three-quarters of 50 states, which would be 38 states total.
Sorry, I said 3/4 or 38 states. I was trying to do the math, but yeah, 3/4 of 50 states, which is 38 states. So the ERA passed Congress 50 years ago, and Virginia became the 38th and final required state to ratify in 2020. But it's still not published or universally recognized as the 28th Amendment. What's the holdup? Is it the courts, Congress, the president? And what needs to happen for it to be recognized as part of the Constitution? Julie, do you want to start? I know you've done a lot of research and thought.
Sure. So the holdup is Article 5, and the holdup is actually the Constitution itself. So let me explain. Article 5 requires two-thirds of both houses of Congress. And what that meant when the ERA was introduced in 1923, like almost 100 years ago, but it never passed 2/3 of Congress until 1972. So that took 50 years. And there were instances where it passed one house, but not the other. But a very important part of the holdup story was that in 1970 to 1972, despite the fact that the House, which had some women in it at that time, they passed it by 96% of the vote in 1970, but the Senate just let it die initially. Then when the Senate finally passed it, some vocal minorities within the Senate, meaning like a few guys who really did not want the ERA, they insisted on a deadline. And so that compromise was made to allow the 2/3 to happen, even though I believe that even without the deadline, there were ultimately 84 votes in the Senate to 8 to pass the ERA. But I think that just points to, we have a political process that's baked into our Constitution that makes it very hard to amend. And it means some vocal opponents, even if there are 8 guys, literally 8 guys in the Senate, they can end up getting what they want, which is a deadline, which for them is better than killing it. And that's what happened. And I think the deadline has really made it difficult because we got 35. And if you think about it, getting 35 states out of 50, by most of the world's constitutional standards, it's like more than enough to change the Constitution in most of the rest of the world, especially when those 35 states include states like California and New York, like the most populous states in the United States. So overwhelming support. But because Article 5 says 3/4 of the states, we came 3 states short by the time the 7-year deadline came up, and the deadline was extended once. Some states tried to rescind their ratifications. So by the time we get up to 38, the story is very messy and complicated, but we do get up to 38. But a lot of opponents still say that the deadline applies. The rescissions reduce the number of total ratified states. And as a result, there's widespread confusion and disagreement about whether or not it really should be added to the Constitution today. So I'll stop there and invite Michelle to add on.
Yeah, Julie, you laid that out so incredibly well. I mean, that's the stalemate that we're in, and there have been legal scholars divided over what could take place next. So should this be able to go forward now that there are 38 states that have signed on? And so is this a matter of just simply making sure that it is certified by the archivist? There's a part of this narrative that includes the Trump administration sending a letter to the archivist warning against doing that. There has been pressure then placed on President Biden to make some effort that would make clear that there would be no type of penalty, punishment, etc., if in fact the archivist were to go forward. But we're in somewhat of a stalemate now, and I think that Julie laid it out so absolutely clearly. And let me just say, as a fangirl, shout out, call out to Julie as well. Everyone should have on their shelves her book. She came on my podcast, listen on the podcast. It's just brilliant work. And it's brilliant work that's been for a very long time examining matters of women in political leadership and the urgency of a critical mass. And I think that people are beginning to understand that now, how important it is that when women are in spaces, that it's not just tokenized representation, but in order for women to truly be able to lead, institutions really need to make sure that there are women who join other women in order to make their voices heard. And Julie's work has been in that space for a very long time, pre-Me Too and all of the sort of current movements that we see where folks are recognizing the urgency and importance of women's political leadership. So.
Thank you so much, Michelle. I'm much agreed. And Jennifer, to you, what does it feel like, I guess, to have worked so hard to ratify the 38th state, and then once it was ratified, it didn't get added, or it hasn't been published as the 28th Amendment? And I know that there's a court case. Can you talk a little bit about that?
Yeah, I can tell you that, I know I stand on the shoulders of giants, of the men and women who came before me, who's been fighting for this very, very long time. I'll never forget, I had an older woman pull me to the side at an Equal Rights Amendment rally, and she looked at me and she said, "You know what, I've been fighting for this since before your mother was alive." And so it really put things in perspective for me. And, after Nevada and Illinois were able to get it done, and then have Virginia to be able to, be that final state, was really gratifying. But I knew that that's just where the fight will now renew, right? And it's just beginning again, because there will be all of these different challenges, like as was mentioned, the oil seat opinion and the deadline. And there were the people who are saying that they rescinded their ratifications for the Equal Rights Amendment. And so what it does for me is just continues to add fuel to the fire. Passing it in Virginia was no easy feat. There were people on all sides of the aisle who came to the conclusion that it's a dead issue, that it wasn't a unifying issue, that it was only a white woman's issue. And so having to work with organizations, not only in the state level, but on the federal level as well, doing bus tours throughout the Commonwealth of Virginia, going sometimes against, leaders in, all parties to take on this issue and say, no, there is no deadline for women's equality, right? And it's an issue and we're going to make it an issue. And, I just want everyone to, know that there are challenges, but also accept your flowers, right? And take your victory lap, because it is something that is to the top of mind of so many people. I'll just never forget watching the presidential debates and hearing the Democratic presidential candidates talk about the Equal Rights Amendment. And I just could not remember a time that had happened, where it was dominating the media and news cycle in a way that was overwhelming. So I know that right now, it's a trying time, but the fight continues. Nothing has ever been given to us, whether it's voting rights, whether it's our ability to own property, whether it's our ability to get credit cards without our husband's name on it or his permission. I mean, every single thing that we've ever been able to obtain has always been because we agitated and we were assertive, and this will be no different. So I am confident that we'll be able to overcome this. What that looks like, we're still trying to attack this from every avenue, but I am still overwhelmingly optimistic.
Thank you so much. And to that point, we are fighting on all fronts, right? So there is the court case that Virginia was leading, but you're now not leading because of the
Our
administration
Attorney
change.
General
But Illinois and Nevada is going forward with, we are working in Congress to remove the said deadline, or to have Congress recognize the ERA as the 28th Amendment. And we are pushing really hard for our Senate vote. And it has passed the House twice. So we're working to get there, and if anyone wants to comment on just giving people hope that there's a path forward. Do you see a path forward that this being part and recognized as our 28th Amendment to the Constitution?
Well, more broadly, I think the question is really important, but I think that you're touching on something that involves the ERA and beyond, that says something about our democracy and where we are in terms of the rule of law, and how so many Americans have become disenfranchised and disheartened, feeling as if the institutions that they most want to respect are perhaps undeserving of the faith and confidence in which they want to give to them. I don't think that we can have this conversation without thinking, let's say, about the last Supreme Court term and the case Dobbs, which dismantled Roe v. Wade and Planned Parenthood v. Casey, and the way in which the court went about doing so. I think it helps to underscore exactly why equality is important, exactly why it is important to explicitly place women within the United States Constitution. And when you look at how the court claimed to be engaged in originalism, but did not do so in any kind of legitimate way. At best, it was incredibly sloppy and wouldn't have even passed a first-year law school exam if you called that originalism. What the Supreme Court was well aware of, but chose not to place in the opinion. So, for example, well aware of the fact that the United States leads all industrialized nations in its rate of maternal mortality. We are around 55th in the world. What the Supreme Court very well knew from the record that had already been provided through the injunction on that law, that Mississippi is a horrific place for a Black woman to be pregnant. 80% of the cardiac deaths in that state are Black women. The awful history of Mississippi in terms of voting rights, specifically related to women, right? Famously, Fannie Lou Hamer being dragged off a bus and beaten in a jail, being placed in a jail because she just wanted to vote. And the effects of that, Black people having to guess how many bubbles on a bar of soap, jelly beans in a jar recite the state's constitution in order to be able to vote. All of these various things, in the Supreme Court saying, well, if the women of Mississippi don't like this, just go vote. Well, what message does that send given all of these histories? And I think that so much of this underscores both why people are disenchanted and feel disenfranchised, but at the same time, why they're losing confidence, but the importance of keeping hope. So how do you hold hope forward in spaces like that? And so one of the things I've been thinking about is that, in the darkest of times, it's when we can best see the light of our stars and the moon, right? And when we think about the stealthness, that women have always brought to what they've done. And Jennifer, I think about exactly what you were saying in terms of the shoulders in which you stand. I mean, the reality is these have been long intergenerational struggles, but here we are. I think about a Harriet Tubman and the incredible work that she did, never losing one person as she would go back and forth into the South to rescue people from the bowels of slavery, something that our military couldn't do until the Civil War. But here was this small Black woman who was able to do that. And if that isn't a message of hope and inspiration, I just don't know what is.
Thank you so much, Michelle. Julie?
So I am a huge fangirl of Michelle Goodwin. And because you just heard her brilliance, I don't have to explain why. And I'm so thrilled to be on this panel with you, Michelle. And I agree 100% with what you've just said. I think that right now, fundamentally, we need to make clear that the Equal Rights Amendment just stands for a proposition that's about much more than gender equality. It is about the life and future of our constitutional democracy. And it is one of the few amendments of the US Constitution that basically say we are not free as a nation until we're all free. And of course, women and gender are a very important part of that vision of constitutional democracy. So the project of constitutional democracy just cannot be complete without the ERA. And most countries realize that in the 20th century. You would never write a constitution today without gender equality in it. And in fact, when the US advises other countries that are writing constitutions, they say, put a gender equality or women's rights clause in that constitution. It's just like a basic legitimizing feature of having a constitution. So I think that's really important, because now what it means, though, is that we're in a crisis. We have a Supreme Court, which, and I'm not just talking about the outcome of Dobbs, I'm talking about the reasoning. And I think that's what Michelle is talking about as well, telling our Constitution's story in a manner that makes it totally consistent with women having no real status and being forced into motherhood, even if, unfortunately, they can die from being forced into motherhood in this country in ways that are embarrassing for an advanced and wealthy democracy such as ours. So that's really important. But it also now, the real crisis, of course, is how do we get to the ERA to the finish line when traditionally in the United States, and I use that word deliberately, traditionally, we think of constitutional rights as something that we trust the Supreme Court to protect. And it doesn't seem like this Supreme Court today and now, even if we give them an Equal Rights Amendment, is going to use the Equal Rights Amendment to optimize the protection of women and girls from violence and other forms of coercion. And so I think it makes it a heavier lift now what the strategy is for getting the ERA over the finish line. But I think one thing we really have to think about is the fact that the ERA, unlike the Equal Protection Clause was a 19th century amendment. The ERA is a 20th century amendment. And in the 20th century, we had a much more complicated and modern understanding of what rights are in a democracy. Rights were not just things that you give to the Supreme Court to decide what they think they mean. Rights were the basis of public policy to actually realize freedom for everyone. And many other countries have developed that in ways that I think the US has lagged behind. But what's very clear when you look at the speeches of people like Shirley Chisholm, the first African-American woman in Congress, Patsy Mink, the first Asian American woman in Congress. You look at the testimony of Pauli Murray, just a legal genius who is just way too far ahead of everyone's time. But you look at all of the things they said about the ERA was not about the Supreme Court. The ERA was about women's empowerment. It was about finding ways for all branches of government to work as hard as they could to make sure that we were all free. And I think we have to emphasize that that's what we get from an ERA, not another right that we hand over to the current Supreme Court majority to decide what they want to do with, but an amendment that empowers people through all branches of government to pursue equality in a very robust way.
Great, thank you so much to both of you. That those are beautiful answers, and that kind of goes to my next question, which goes, beyond just rights and specific protections. That some people say, that we no longer need the ERA, although I think that's changing a bit. And they point to the Violence Against Women Act, the Lilly Ledbetter Fair Pay Act, the protections the 14th Amendment has been able to use. So what would you say to them who are, pushing back? Because it's, as you're saying, it's an uphill battle, something that takes a lot of work. What are we missing here? What could the ERA provide that doesn't already exist?
So I guess I'll chime in here, and I would be remiss as well if I didn't say I absolutely fangirl Michelle as well, and I'm excited to be on this panel and hear these responses. But the thing that I would have to, initially respond with is what the late Justice Scalia said when he said that certainly the Constitution does not require discrimination on the basis of sex. The only issue is whether it prohibits it, and it doesn't. And so it was very clear in that moment that, yes, we may have the 14th Amendment and the Equal Protection Clause that gives us some protections against sex discrimination, but definitely not as much as race discrimination, which has the highest standard under strict scrutiny. And women or discrimination against women by the government can be done, but the barrier that they have to overcome is much, much lower. And so what we're saying is that's not sufficient. And we want to ensure that we do not have discrimination based upon sex. So there are so many other things that are at play here, and making sure that men know that this is beneficial to them as well, right? You have some states that have inferences or presumptions that, for example, if there's a divorce and they're looking at who should have custody of the children, well, some places do believe that women are better nurturers, and therefore they should have a presumption or there's a tendency to award custody and care of children towards women. And so again, whenever you have laws based upon gender and sex stereotypes, that doesn't benefit society, right? And so again, it helps all people when you're talking about the Equal Rights Amendment and how important it is. It's not just symbolic, it is something that can actually really substantive address the patchwork of laws that we have throughout this country, right? How many rights I have shouldn't depend upon what region of this country I live in or what my area code is. And when you have patchwork of laws to protect women or some to hurt women, then that's problematic. And so having a Equal Rights Amendment, it will go so far, even with states. Some states have state equal rights amendments. In Virginia, we have a state equal rights amendment. And I believe 21 states have comprehensive equal rights amendments in their constitutions that explicitly bar in denial of equal rights under the law on the basis of sex. But we want to make sure that everyone is protected. We want to put this in our founding document. We were intentionally left out, and we need to be intentionally put in and really fulfill the promise of this country and build a more perfect union. And the way that we do that is by acknowledging and accepting the fact that discrimination based upon sex is it's unconstitutional, it's immoral, it's wrong. Make it illegal. And I think that will go really, really far as, in this fight towards equality.
Thank you so much. So speaking of everyone having, the Equal Rights Amendment is applicable to everyone, especially following, the Bostock Supreme Court decision that recognized LGBTQIA+ rights as sex discrimination. How could the ERA allow lawmakers to pass laws that better support the LGBTQ+ and gender non-conforming community and uphold their rights. And do you see that as something that the ERA could do?
Well, I'll start with that, and I would say potentially yes. So, building off of Jennifer's really brilliant commentary there, one significant aspect, legacy, residue of histories of discrimination, which we don't even account for, right? I mean, there's just such a deep legacy of the hundreds of laws that saddle women with unequal citizenship. Even the fight for the court to recognize women's citizenship after the ratification of the Reconstruction Amendments says so much. I mean, most law students have no idea that, cases at state and also US Supreme Court for women to become lawyers, and the Supreme Court saying no, state Supreme Court saying no, not even to serve on juries, can't even become serve at the bar or the restaurant that you own. I mean, just legacies and legacies. And when you look at how the court handles state-based discrimination, you discriminate, despite the fact that this is a court that has been dismantling, half a century of progress in that domain. That aside, the reality is that, states are held to a compelling interest standard. It's strict scrutiny that the court will engage in when there are matters of racial discrimination. But there's a different standard if you want to discriminate against women. You're not held as a state to that high standard. You got to so reason to discriminate against women. Well, that's okay. This level of intermediate scrutiny. There's so many problematic vestiges of sex discrimination that continue to persist in law that are urgent to address. And you've mentioned the Bostock case, which is a fascinating case because it's a case that is written by one of the new conservatives on the court. Justice Gorsuch writes that opinion. It's an opinion where there are multiple originalists on the court, and they're all coming out in different ways. Maybe that's a good thing about originalism, sort of shows that you could come out in different ways, or in the same time, maybe it shows that perhaps there's not as much there as people suggest, because it's hard to actually land on what exactly is originalism. But at any rate, it is the case that says that, states may not discriminate in employment against individuals who are LGBTQ. Specifically, there were individuals who identify as trans who had lost their jobs based on discrimination, and they brought suit that this was sex-based discrimination. And the Supreme Court said that, yes, it was, and they were able to prevail before the Supreme Court. But I do think that, again, when we sort of think about where this court is, and we think about Dobbs, and we sort of think about the sort of legacy of protections, those legacies of protection even are really quite vulnerable, even before this very same court. If you look at Dobbs, the Supreme Court suggests, the majority, that there are guardrails around its decision, that its decision only applies to the dismantling of the abortion right. Various other rights that have emerged over time that have been connected to privacy are okay. And then you read the concurrence by Justice Thomas in particular, where he says, wait, no, that's not the case. Interracial marriage, yes, something that affects him personally, but everything else is up for grabs, right? So I do think that we're in a very vulnerable time in terms of our democracy. And then following that, we see Senator Lindsey Graham, coming forward and saying, yeah, well, let's take this challenge to a federal landscape. So yes, the ERA is urgently important, and I believe that, and I think we need to think about it within the context of protecting more than women, but individuals who are non-binary, individuals who are trans, people who are LGBTQ, broadly within the scope of what could come with having an ERA ratified.
Thank you so much.
So in some ways, my answer is slightly different and perhaps simpler than Jennifer's and Michelle's, because I think what the Dobbs decision and what Michelle was saying about the manipulability of originalism as a technique of legal interpretation, but it's not just originalism. I would say there are many, many legal techniques that could lead to very different outcomes. when you're thinking about words that have many meanings, including sex and gender, including women. And so what that means that all of the things that Jennifer mentioned that have been problems with regard to sex discrimination in the law, there are problems to which the ERA might provide a solution, but it depends who's interpreting the ERA. And furthermore, there are things like the Equal Protection Clause, which I think Ruth Bader Ginsburg very brilliantly, and Polly Murray before Ruth Bader Ginsburg, very brilliantly were able to use things that already existed to expand categories, achieve protections for women. So my answer to Patina's earlier question as to why we need the ERA is not to come up with practical fixes for all these specific legal problems, because I think we can get practical fixes. Women lawyers have been brilliant throughout history. I think Dahlia Lithwick's new book, Lady Justice, shows that. What women lawyers have done that's so brilliant is use a lot of tools that have been created by men and by patriarchal legal systems to achieve liberation for women. And even the ERA is a little bit of an outgrowth of that in its framing of equality of rights. So I don't think that we need the ERA to fix all of those specific problems of sex discrimination, or even to fix some of the bad interpretations that the Supreme Court has come up with. But what I do think we need the ERA for, which is what I've tried to write about by lifting up women like Shirley Chisholm and Polly Murray and Barbara Jordan and Liz Holtzman and Jennifer Carroll Foy and Jennifer McClellan in Virginia, all these women and women of color who have been empowered, is that we have a long history of women being founding mothers. We have a long history of women making Constitution. And the longer we keep them invisible by saying they don't get to be in here. I'm sorry, I've got a blur background, but this is my pocket Constitution. But I think that not having the ERA is a way of saying we have women who have made Constitution, but they're invisible. They are not founders and framers. They are not venerated. They don't speak authoritatively about the law. And I think that's actually deeply damaging to the legitimacy and future of our multiracial, multigender constitutional democracy. So in some ways, it's very basic. I don't think we need it as like a fine-tuning legal tool. I think we have a lot of tools, but I think fundamentally, this empowerment and inclusion that starts with who is a constitutional founder, framer, authority, who is empowered, that is something that I think there's no substitute for having presence in the Constitution.
Tina and Julie, if I can add to that, I really appreciate Julie's framing there. One of the things that comes to mind with it is, and particularly with thinking about the fact that we have a very old Constitution. There are nations around the world that have far newer, more progressive constitutions. And to the point made earlier by Julie, that we have US legal advisors that when consulted on those new constitutions, offer advice that there must be a line there, that there must be substantive equality that is baked into those new constitutions, even though we've not done it ourselves. But it also leads to the next issue, which is that the sort of sense that our Constitution must be restrictive, that our Constitution may not have language that addresses all of these other concerns that you've raised. I mean, I see the ERA as also a point of inspiration and aspiration, that maybe as a starting point, a renewed point, it does not have to be an end point. When you think about histories of discrimination against individuals with disabilities, for example, there's no explicit referencing in our Constitution that addresses those concerns. And yet, I think that we have evolved as a society to understand that individuals with disabilities should not be shut out of society, that they deserve equality, that they deserve dignity in society, that they should not be discriminated against from having the opportunities that others do. And yet those protections have been hard to come by. So one way of thinking about the effort that's taking place now is something that is actually broader than the ERA and what it could inspire beyond the scope of what its language happens to be.
Fantastic. Thank you both so much. And yeah, so I mean, I guess that sort of gets to the question that I was about to ask, which is, you know, what impact do you think the ERA will have, not just on the ability to make laws, but in the way that society treats and views, especially for women of color who, Julie, you referenced a lot of your scholarly work, which was uplifting that so much of where we are is because of women of color, both in the 70s, Julie Chisholm, Pauli Murray, and the nows, Jennifer Carroll Foy, Jennifer McCullen. So how do you think that the ERA could actually help benefit society's treatment and views for women of color, persons in LGBTQ plus communities? Do you think that having it in the Constitution will really kind of create a seismic change, and maybe even laws will catch up because of that?
So I don't think of constitutional change as seismic. Let me put it this way. I think that the process of trying to get the ERA, which is not complete, reveals something about Article 5 and the path to constitutional inclusion that's actually very troubling in the United States. It's very troubling that women have tried this long, and it's ambiguous as to whether the ERA is part of the Constitution. And what that tells you is that we essentially have an unamendable Constitution, at least as it exists right now. The ERA was the last time that Congress in such overwhelming numbers adopted an amendment. We haven't had an amendment added to the Constitution since I was like not yet old enough to vote, 1992. I was 17 years old at the time. And that amendment was written by, guess who? Slaveholding founding father, James Madison. It's about congressional pay. So I think the fact that the ERA has had such overwhelming support and such amazing effort by women and women of color, but its constitutional status is like a big question mark, that should tell us that our process of constitutional change has not been inclusive, and that is a problem. So now if we're going to work to get it into the Constitution, and I think the political process, specifically the congressional strategy of getting the Senate and of course the Senate is responsible for that 7-year deadline in the first place, but getting the Senate, which I understand to be an uphill battle, but getting the Senate to remove the deadline or to recognize the validity of the ERA now, and not just getting them to do it, getting people to talk about why it's important now in this moment, so that it becomes part of the legislative history and part of the original meaning of the Equal Rights Amendment. That's incredibly important. I think if that can happen, I think it will open up the path to constitutional change. And it's a path that has been blocked for at least 50 years because the last amendment we got was 30 years ago, and it was an amendment that was written in the 18th century. So I think that opening up that path is really important, not only because of what the ERA brings, but then opening the way to other forms of constitutional modernization that we actually need, including the inclusion of other marginalized groups that have not been constitutionally included, and including, very importantly, focusing on why we have institutions, including the Supreme Court and the Senate, that are not very representative and over-empowered in ways that block legislation and public policy that the most marginalized groups actually need.
Thank you, Julie. And I want to just open that to Michelle and Jennifer really quick before we go to our final question before Q&As, but I want to make sure everyone has an opportunity to respond.
I guess I'll go because I don't want to go after Michelle. So I would say that while acknowledging the advocacy and the fight that Black women have played, especially when you're talking about the Equal Rights Amendment, I definitely have to shout out my friend, Senator Pat Spearman in Nevada. I have to talk about Lieutenant Governor Juliana Stratton in Illinois. I have to talk about State Senator Mamie Locke here in Virginia, who helped rally the troops when there were some people who said, maybe we shouldn't pass the Equal Rights Amendment because if we make it, if we don't do it, that'll excite women to come out and vote. And it's like, no, we have to do this because we need it now and it's the right thing to do. So also wanting to pay homage to those women and make sure they get they receive their flowers as well. And so for me, I do hold true that I think that having a equal rights amendment can bring about a significant change. And I base that upon looking at what's happening amongst the states. And so state level constitutional provisions have been a huge source of individual rights. It's been what the states or women or people who've been discriminated because of their sex or gender in states have used to draw on in order to bring challenges. So the state equal rights amendments have been the basis for finding a right to marriage equality for same-sex couples and for prohibiting restrictions on abortion funding and state Medicaid programs. So I would hope and I would think, because it is true, we truly don't know until the courts interpret and define what is sex, what is gender, what does that mean? I mean, we even look at the 14th Amendment and there are still challenges being brought to the Supreme Court defining the language of the 14th Amendment. So I am optimistic that, and I am hopeful, or maybe I just really want for it to bring forth big and bold change and help us get closer to closing that gap and obtaining constitutional equality. So, I just, want to acknowledge and thank you all for, bringing up that intersectionality, that Black women and being a woman, being Black and being a woman and that intersectionality, that's why we fight. And we want to bring as many people with us. And I think that has caused some discourse in the past where you have people who are siloed and say, we're going to fight for this or that. But no, we have to bring everyone along because, if everyone doesn't have equality, no one has a true equality. And that's the basis upon it. But thanks.
So what comes to mind for me with the question is how important it is for us not to rest on our laurels. And it is important. Legislative victories are incredibly important, and constitutional ratification of amendments that help to further the arc of justice are critically important. But we also have to be mindful too that we must remain vigilant, that it's not enough to simply have law on paper, that it can sadly be rendered meaningless, right? So there was the ratification of the 13th, 14th, and 15th Amendment, Reconstruction amendments that should have been able to sustain and help to serve as a lever for equality and to fight against the ways, both in terms of dignity harms and other substantive harms that people of color experienced, that Black people experienced. But it was worth noting that, barely 20 years after the 13th Amendment was ratified, the civil rights cases before the United States Supreme Court said that it's time for Black people to become mere citizens. That Black people have been treated far too long as favorite people that you just simply can't make up, right? And then we see Plessy v. Ferguson and a series of cases that strike against the heart of the 13th and 14th and 15th Amendments, such that then in 1964, we need a Civil Rights Act to be passed by Congress. In 1965, we need a Voting Rights Act passed by Congress, when some might say, well, shouldn't that have been the work of the 13th Amendment, 14th Amendment, and 15th Amendment? So I think it's important that we're also mindful of the struggles that we're in, and so that even with getting to a promised land with the ERA, it's not enough. We have to be mindful, we have to be vigilant. Voting matters. Voting not just up ballot for people who run for president, but also voting at the local level, school boards, people who are city planners, like all of that is just really critically important in order to hold on to our democracy and to protect the rights that we fight for that are embedded in legislation and in the Constitution.
Thank you so much. And that really gets to our final question before Q&A. I think you already answered it, but what do you think the people here today watching along with us or watching on our social media channels can do to help get the ERA added to the recognized as part of the Constitution. I heard vote, so I don't know if you want to expand on that. And Jennifer and Julie, what would you like to share with our audience? I'll pick on Jennifer. I'm just kidding.
Okay, thanks. Okay. And so for me, you know, of course, absolutely voting. Whenever you have marginalized communities, you know, the best way the best way for them to be able to achieve equality, fairness across the board is to, you know, be at the table, be in the rooms where the decisions are being made. And we do that by flexing our political muscle and voting, making sure that we recruit candidates to run who values align, and then supporting those candidates and helping them get into office so they can make systemic change. I mean, I have to tell the people on this call, but I can tell you after 2017 here in Virginia, where we elected a number of amazing, dynamic, fantastic women, I don't have to tell you the type of legislation that was being proposed. Paid family medical leave, paid sick days, affordable childcare. It was a Medicaid expansion, more legislation to help small women and minority-owned businesses, ending pregnancy discrimination, making breast milk covered by health insurance. I mean, these are the practical, pragmatic policies that are being pushed and passed when you have more people who understand the experiences that we have actually putting bills and budgets in place in order to move Virginia and our country forward and do practical things that's needed. I mean, just historically, we work more collaboratively. We're different leaders, better leaders, I would argue. We're efficient, we're effective, we're able to get things done. I just think women are amazing. But at the end of the day, you know, we have to be in those rooms. We can continue to beg and plead, or we can grab and take, right? And I kind of think that that's where the sentiment is now. We see what happens when we take a back seat and we're the tail and not the head, right? Our bodily autonomy is taken, right? Our rights to vote are taken. You know, in certain circumstances, you know, our civil liberties, everything. I mean, one of my friends recently said, Jen, I'm really worried because, you know, in places, you know, like India and other places, you had these things that happen, and it's kind of like being a frog slowly boiled to death. Slowly your rights start being taken away. And then you look up and you say, well, what happened? How do we get here? And I see us on that trajectory, and I'm concerned and worried. So I think absolutely voting, joining organizations like the ERA Coalition, you know, you have the National Organization for Women, you have so many feminist majorities, so many amazing organizations that's out there, because our voices ring louder when they ring together. So joining amazing organizations out there who's out there taking a charge, helping to do the work, pass the policies, and doing all the things that need to be done is also something that you can do, because they need help, they need resources, they need funding. And so I think that's where we are. And, you know, calling out power and privilege where it is. Power and privilege is a true challenge and issue to so many groups obtaining equality, hard stop, whether it's LGBTQ, whether it's women, you know, across the board. So really, really taking that on in a real way and advocating and lobbying and you know, that's how we're going to get to where we need to be. Again, none of our rights have ever been given. They've always been taken, and this will be no different.
Thank you so much. And I've been told that we do have a ton of Q&A questions from the audience. We might only have time for one, but hopefully we can get you the rest of the questions after, so you can just see everything that the conversation spurred in everyone's minds. But I'm going to ask Chrissy West, our communications director, to read off at least a couple. Chrissy?
Yeah, I don't know if it's possible to do this as a lightning round and just as quickly as possible. We do want to be respectful of everyone's time. I know Professor Suk has a hard stop for her next class, I think. So, and Michelle as well. So both our professors have other things to do. So our first
going on, so I can.
No, well, I'm sure Jennifer, you're quite busy as well. So you can all hang out with me, but our first question for the lightning round: do you think the opposition and/or reluctance in the Senate is solely related to legal issues with state approval not meeting the deadline, or is there true resistance to the ERA as an issue?
Michelle.
I was thinking that actually Julie would be really good at
Julie.
addressing that. Well, just because, so it's an interesting thing, the sort of use of the deadline as a proxy, right, for resistance. So I would imagine that if surveyed, there would be senators, and they were asked, well, do you believe in women's equality? I mean, even those who've been very, sort of articulating against women's equality in terms of reproductive freedom, that's something that they probably most would not want to go on the record saying, I don't believe in women's equality, even though I think if asked the question about the ERA, who knows how some would actually come out on that question. But I think that they get to avoid that altogether, those who might be conservative and resistant about it, by using the data as a proxy for that.
Thank you. Julie?
Yeah.
So I've been trying to think about your question, Bettina, because I think it's complicated. What can we do now? And I fully agree that we should vote, but I've been closely watching the voting rights cases that are before the Supreme Court. And almost everything I'm going to say that we can talk about that we could do, there are barriers that are being put up by the courts and by other institutions in power that make it difficult to fairly achieve success by voting. It makes difficult to fairly achieve success by litigating, difficult to fairly achieve success by going to your elected officials. And what I mean by difficult is not just are the votes there, but things like the Senate filibuster, right? And unfortunately, I think the big problem right now with regard to resistance in the Senate, this was not true in 1972. ERA was not a partisan issue. And it would not have passed without the support of many Republicans in the 1970s. And right now, I think because of the filibuster, it needs to be a more bipartisan issue. And I say this, but it's hard because there are very few things on which there's bipartisan agreement right now. And it just does reflect that the ERA is kind of the tip of the iceberg, which is a lot of features of our democracy have broken down in recent years. But I also think that working on ways of getting this thing on which there really should be agreement in the United States. What I fear is that if you wrote an amendment today that just said the United States is a democracy, it would not pass 2/3 of Congress. And I'm genuinely worried that if you propose that, it would not pass. So I do think that what we really need to think about is mobilizing people on all fronts, not just voting, not just litigating, or especially not litigating, given what the courts have been doing, but focusing on showing up in multiple realms and having conversations just at the local level about why our 18th century Constitution is actually a very poor fit for everything that we need to do to be a truly inclusive society in the United States today.
Thank you
Thanks,
so much,
Julie.
Julie.
I do think that Julie sort of answered the second question in the Q&A box, which was asking about if we had to start the ERA process over, do we think that would move quickly and be approved? It's very likely that would happen, probably for at least another generation. So we'll move to our next question in the lightning round and probably our final one because we do need to close. Biden promised to codify a person's right to abortion healthcare into law. Can that right be included into a sweeping ERA package to be passed, or does it need to be separate because one is an amendment?
Well, right now, anything you propose that doesn't match the exact text of what was adopted by Congress in 1972 would be a new amendment. And so that would be a start over, which was your last question. Because I think in many respects, if we were starting over, I don't know that we would choose the same wording that was adopted in 1972. Maybe we would have more intersectional language in it. Maybe we would include the disabled. Maybe we would do different things with that amendment if we were introducing a new one today. But the one that was introduced in 72 got 2/3 of both houses of Congress and got 3/4 of the states, notwithstanding the deadline. So, but I do think that it is worth pursuing the codification of reproductive rights as a statutory matter. And we have broad popular support and the votes in the Senate to do it. It's just been filibustered. And
it-
so I don't just think that all of these projects, whether it's the ERA or reproductive rights, we can't argue for them without also thinking about broader structural issues like the filibuster and the design of our basic institutions and Supreme Court reform. And I think I would encourage people to every conversation about the ERA also has to be about the institutions that have historically blocked the ERA, because these are related issues.
Mm.
And codification of Roe v. Wade is not the same as ratifying a constitutional amendment, right? So it's a much lower bar in order to be able to do so, but one in which there is a dramatic tension within the process of governing in our Congress that relates not just to the Women's Health Protection Act, but many other areas of law that would be difficult to move along. I think that there's a lot to be learned from the past. And so I want to close with just thinking about the importance of a third Reconstruction. If we can think of the first Reconstruction as the 13th, 14th, 15th Amendments, starting in the 1860s, the 1865 ratification of the 13th Amendment, and then with the civil rights laws of the mid-1960s as being perhaps a second Reconstruction, we're due for another one. Hopefully it wouldn't take us until 2160s, something that would come much sooner, but I would hope that we could keep it. And by keeping it, that we could be vigilant, that we could make very clear that our Congress would be a place that's hospitable to people who are blatantly racist, sexist, homophobic, anti-Semitic, and that all would be done to make sure that we have a Congress that reflects the values that are embedded in our Constitution and the laws that we enact. So I'll leave it at that. There's so much more to be said, and I've just been very grateful to be on the conversation today with these wonderful folks here, both Julie and Jennifer, and thank you, Bettina.
Thank you so much, Michelle.
Thank
Well, that
you.
is real. So, Chrissy, so I think that that's all we have time for today. Just respecting, I know that both Professor Suk and Goodwin have to leave. But I want to thank you all for your thoughtful questions, and to our speakers for their insightful responses. We hope to see everyone again soon for our next conversation in the Harnish Town Hall series. And before then, we hope you'll all visit www.electequality.org to find your candidates for office who support equality and the ERA before heading to the polls, and please vote. So thank you. Have a great rest of your day. And thank you so much to our panelists. It was such a wonderful conversation.